You're about to see edited highlights from one of the lengthiest and most complex cases in legal history. Everything about it is highly fictitious, and the proceedings are not all that legally accurate. The characters in it are played by actors, and the jury is made up of people who've expressed their willingness to arrive impartially at whatever verdict may be required of them. The case concerns a libel action brought by Cosmic Planning Consultants against the Rosenberg Research Foundation, and counsel for the former is now opening his case.
I appear for the plaintiffs, my lord, and my friend Mr. Keith Saunders is counsel for the defendants. I propose first to outline the facts of the case, which is in essence a simple one, turning on the fact that a building on the edge of a steep escarpment in the Cairngorms, some 3,000 feet or so above sea level, was in 1975 turned into an old people's home with the usual facilities. Of these facilities, it is with the lavatories that we are principally concerned, in that these were placed at the foot of the escarpment 3,000 feet below the old people's home they were intended to serve. It was my clients who were acting as consultants in the matter and who are bringing this action against the defendants in respect of a libel contained in a letter and later in a newspaper interview. If I might crave the indulgence of the court at this stage, my lord, I would like to go over briefly the background of the situation. The facts are not in dispute between us. The original name of the building, which underwent conversion in 1975 to an old people's home, was Bellamy's Folly, an edifice constructed in the early years of this century by one Horace Bellamy as a left luggage office. It was intended as the first of a chain of left luggage offices encircling the globe and enabling those with heavy luggage and finding themselves at the top of some mountain or other to have somewhere to deposit the luggage while they themselves admired the view and ate their sandwiches. It was a bold concept, but one which was in the event doomed to be stillborn. The harsh facts were that people could not be persuaded to take their luggage to the top of an escarpment in the Cairngorms or in anything like sufficient numbers to justify the considerable expense of maintaining it there. The building accordingly fell into disuse, remained empty for some time, becoming known as Bellamy's Folly. He himself, embittered by what he thought of as unfair competition from the left luggage offices in the mainline termini, which had at that time gained a stranglehold in the left luggage business, finally committed suicide by casting himself down from the withdrawals counter, or what had been the withdrawals counter, to the foot of the escarpment, 3,000 feet below, hitting the ground by a curious coincidence at the very spot where the lavatories were to be built over 50 years later, in the people's home to which reference has already been made.
Did you say competition from the mainline railway termini?
That is thought to have been in his mind, my lord.
Is it being suggested that someone at the top of the Matterhorn or of Everest, since that was in his mind eventually, would go to the trouble of making a descent of 10 to 20,000 feet with a heavy suitcase in either hand, in order then to travel perhaps several thousand miles in a stuffy and uncomfortable train with no other purpose but to deposit his suitcases at Euston Station, possibly meeting surly and offhand treatment when he got there?
No, it seems a few people were making the original journey, my lord, from Euston to the top of the Cairngorms or wherever.
Well, what inducements were offered them?
Well, it was thought that the challenge itself would be a sufficient inducement, my lord. That is the plaintiff's case, my lord, and I will now call my evidence. Call Kenneth James Hoist Petard.
Counsel for the plaintiffs has called the head of the Rosenberg Research Foundation to the witness box. It will be his purpose to show that there were sound reasons for the publishing of the allegedly libelous words.
Bellamy's Folly, as we must continue to call it, was intended to be very much the showpiece, was it not, as the first in the line of similar homes for the aged in other high spots elsewhere in the world.
It was, yes.
It was indeed received with considerable acclaim in the press and elsewhere. A tremendous breakthrough, a triumph, one paper put it, of high-altitude geriatry.
We were pleased with the response.
As a result, the result of this, it was inaugurated with great pomp and ceremony in a blaze of publicity.
We were happy with the coverage.
Is it not true that such experiments in high-altitude geriatry as were urgently needed at that time could have been carried out every bit as effectively and, some may say, far more humanely by sending one or two selected old-age pensioners up in a hot air balloon once or twice a week from, say, Cockfosters?
This was very seriously considered, and it had a lot to be said for it. But in the end, we opted for the left luggage office.
In order the better to acclimatise the, as we may now say, unfortunate guinea pigs in this experiment to relatively high altitudes before sending them into orbit for reasons of limited space on the ground.
That was part of the object.
Great-grandmothers in orbit. A concept that, given this kind of publicity, could not fail to appeal.
I think the time was ripe for it.
And accordingly, it caught the imagination of the public.
It did, yes.
I cannot possibly allow counsel to go on leading the witness in this way. You really must try to phrase these questions in a less tendentious way.
I'm obliged to your lordship. To what extent was this whole enterprise not something of a pipe dream?
We felt it had great potentiality.
Would it be true to say that Rosenberg Research Foundation were being somewhat starry-eyed about the whole thing?
We had our feet very firmly on the ground.
More firmly, perhaps, than some of the unfortunate old-age pensioners, who had ill-advisedly opted to act as guinea pigs, one might perhaps say. At all events, it has to be admitted, does it not, that the whole concept quickly became, in the minds of the general public, a damp squib, a 9 days wonder. And public support accordingly fell off with alarming and disconcerting rapidity.
It didn't catch on quite in the way that we'd hoped.
Nor, I would suggest, was the diminution in public support the only problem confronting you. Other snags were beginning to come to light. Many, for instance, of the firms who'd agreed so eagerly to deliver provisions and groceries and other necessaries when this had been a matter of climbing onto a popular bandwagon were now beginning to have second thoughts.
This was fomented
When a couple of removal men jibbed at carrying a Welsh dresser up the sheer face of a 3,000-foot mountain.
They were troublemakers. And it spread.
With the result that the old-age pensioners themselves were compelled to make first the descent and then the ascent to collect their own shopping.
For a time.
Not an easy matter for someone of advancing years with a full shopping basket, I would presume.
It did raise a certain amount of comment, yes.
I would suggest that public disquiet was considerable, that questions indeed were asked in the House.
That is true.
Might it be true to say that you found this project somewhat embarrassing?
It wasn't something that we welcomed.
How convenient, then, if you could find a scapegoat on whom to foist responsibility for this unwelcome development.
There was no intention of foisting responsibility at all.
Nevertheless, if it could be made known that some gross oversight had been perpetrated, not by you, but by the plaintiffs, an oversight whereby the inmates of the old folks' home could be shown to have been put to some minor inconvenience, it would deflect a great deal of public criticism away from you, would it not, and on to the plaintiffs. And what better such oversight than the placing of the lavatories in such a position that it would be impossible to reach them in the middle of the night without wearing climbing boots over one's bedroom slippers?
This was not the intention at all.
Thank you.
I have no questions to ask of this witness, my lord.
None?
No, my lord.
So be it.
In the absence of cross-examination, counsel for the plaintiffs calls his next witness, the Cosmic Planning Consultant's Chief Planning Advisor, Nigel Winterbourne.
As a consultant of some standing in the consultancy world, you're well versed, are you not, in the art of consultancy?
Many people consider so.
To the extent that it would be true, perhaps, to say that you have consultancy in the blood, and that consultancy, in all its myriad forms, has been your life right up until this moment, and indeed still is.
I'd like to think so.
You showed a certain precocity for this, even as a child, I believe.
I was said to be forward, yes, in that particular field.
With the result that in adult life, you have been called in on a consultancy basis on numerous occasions in the non-communist world. You are now, are you not, chief planning advisor to the cosmic planning consultants who are the plaintiffs in this action.
That is so.
And as such, you were intimately involved, were you not, with the project about which complaints have been made?
I was.
Project was a somewhat ambitious one, I presume.
It was one of some magnitude, yes.
Is it perhaps to be expected that in a project on so large and ambitious a scale, minor snags might be expected to appear?
One would be very lucky to get it absolutely right first time.
Such a mistake as putting lavatories at the bottom when the home they were to serve was at the top might be an oversight of no great order, perhaps.
It might seem so to the individual old age pensioner called upon to make the journey down and then up again, but in terms of the project as a whole, it was considered a very minor point indeed, hardly worth the expense of rectifying.
Thank you.
Are you cross-examining this time?
Your Lordship's permission.
By all means.
The peace and serenity which it is normal to associate with a home for the elderly in their declining years is in danger of being put at some risk, is it not, if one finds oneself trudging some 3,000 feet down a steep escarpment with many treacherous overhangs in one's dressing gown at 3 o'clock in the morning to attend to a call of nature. There's a danger, certainly. Might there not be prima facie grounds for complaint by some who think this is no way to spend the autumn of one's life? It's not easy to please everyone. The comment might be made as to what might appear at first sight to be an absence of forethought, to the extent that the question, what kind of planning consultants are these, might find itself being asked in certain quarters with an element of rancour. Well, this is something one has to learn to come to terms with. What was passing through your mind in citing the lavatories where you did? I was thinking of Mrs. Letchworth. What was the tenor of your thoughts concerning this Mrs. Letchworth? It occurred to me that she was highly desirable and that I had a chance there. In other words, your thoughts were elsewhere than on the job you'd undertaken to give your undivided attention to. I suppose that would be so. A case, one might say, of cherchez la femme. Yes, one might say that. You said that, in your opinion, the oversight was a minor one, that it was an oversight of no very great order, except to those inconvenienced by it. What about the danger that in bedroom slippers, a 93-year-old lady, not perhaps too steady on her pins, as the expression is, might miss her footing and fall from top virtually to bottom? A feasibility study was carried out in 1970. No dangers of that nature were anticipated. Is it true that there are mattresses placed against the bottom of the sheer north face, against this very contingency? Unanticipated though you say it was. These were placed there subsequently. As an afterthought, and in response to public outcry, when it was found that old-age pensioners, falling from some considerable height, were going straight through to the underworld on hitting the ground.
To the where?
The underworld, my lord, sometimes known as Hades.
You mean the infernal regions?
Yes, my lord.
Then say so.
Indeed, it is true, is it not, that some of the pensioners, even after the provision of mattresses, were continuing to go straight through, this time taking the mattresses with them. And I put it to you that it is no part of the divine purpose that man or woman should, after leading a possibly blameless life for 70 or 80 years, make his or her entrance into the infernal regions like a sack of coals coming down a chute, arrive in Hades unannounced and wrapped in a mattress. And one might be said to have got off to a dubious start so far as the afterlife is concerned. It could lead to problems. It could lead to eternal damnation. I suppose so, yes. Scarcely an inviting prospect, mattress or no mattress. I suppose not.
It is to establish this vital point beyond any shadow of doubt that at a later stage in the hearing, defense counsel brings a man of God to the witness box.
If one was so unfortunate as to be damned eternally, one would know all about it, I presume.
Oh, yes, indeed. And it is for this reason, in the main, that one advises one's parishioners against it.
Nothing to look forward to except an endless round of sin and vice, indulged in unremittingly for the better part, perhaps, of eternity, until such glamour as it might once have had has long since departed from it.
That would be about the size of it, yes.
It would take all pleasure out of the afterlife and leave one feeling fit for very little afterwards.
Anyone of pensionable age would very likely find it too much for them.
Nor, presumably, would there be any getting out of it at all easily. If you don't take part with the others, show willing, as the expression is, you are looked at, one imagines, as something of a leper, and might possibly be sent to Coventry by your fellow damnees.
It is possible to get out of it by pleading sick, if you don't for any reason feel up to it for an eon or two. But they're not exactly enraptured when you do.
Satan, in particular, taking a somewhat poor view.
Satan would come down like a ton of bricks.
One would come, moreover, would one not, on frequent occasions, face to face with Satan.
That is so, yes.
Who is not the sort of person one would want to meet on a dark night, I would imagine.
Indeed not.
Many a person has been frightened out of his wits by such an encounter unexpectedly.
But one would normally say, in that sort of situation, get thee behind me, Satan.
One would scarcely feel any safer with him there, I imagine.
He has been known to take advantage.
Almost too great a temptation to resist, one would imagine.
I think at this point we might resist the temptation to go any further with this line of questioning. We will adjourn and return at 2:15.
As we return to Crown Court, cross-examination by counsel should be continuing, but a hitch has occurred, whereby a Mrs. Startferret has taken the place in the witness box of the Chief Planning Advisor, having asked to be seen early and out of turn, owing to commitments elsewhere. As her evidence has nothing to do with the present case, counsel is having to rephrase his questions in the light of this.
This is highly irregular. You do realise that?
Yes, I do, Your Honour.
Well, you must bear that in mind throughout. Otherwise, you may find yourself in contempt of court, in which case I shall have no alternative but to sentence you to be detained in the cells until such time as you have made a full and unconditional apology to the court.
Yes, I am aware of that, sir.
And as a result of this, you paid a visit to a solicitor, I believe.
That's right.
Are we taking this evidence in the middle?
It would seem better that way, my lord.
Very good.
Can you tell us how this visit came about?
I was talking to my friend and telling him what had happened, which I won't bother with now. And he said, would you like to see a solicitor? So I said, I've already seen one. He said, where? I said, on the television. He said, would you recognise him again? I said, yes, anywhere. So he said, right, what are we waiting for?
And as a result, you fetched up, I think I'm right in saying, at the offices of Purdue, Gabbitas, Tatchbrook and Hobart, Commissioners for Oaths.
Yes, to see Mr. Hobart.
Whom you immediately recognised as the one you had seen on television.
Oh, yes, it was the same one, all right.
And your first words to him were what?
I said, can you hear an oath? And he went across to the open window with his hand cupped round his ear and he said, no. I don't think so, can you?
Whereupon?
Whereupon I said, it's my brother-in-law.
Your brother-in-law comes into this in what way?
Well, he'd hurt himself.
Having hit his thumb with a hammer while nailing up a picture of the infant Jesus.
That's right.
And he wanted, without delay, to come out with an oath of some description in order to relieve his feelings.
He was hopping about from one foot to the other.
Having been bottling it up for some time while you were looking for a solicitor, and with a homemade gag in his mouth to prevent the premature utterance of the oath.
That's right. He was all set to utter it the moment the gag was removed.
When the formalities were completed?
Yes.
What was the oath he was all set to come out with?
Well, may I write it down?
Yes, she can write it down.
Hells, bells, and buckets of blood.
There were several possibilities. He had a list. That was his first choice.
What was the reaction of your Mr. Hobart, the solicitor you had seen on television and were now confronting in the flesh, to the information that this was what you wanted to see him about?
He was very understanding and produced this chair leg.
Chair leg?
It was about so long, my lord.
With what purpose in mind?
Well, he said the formalities might take some little time.
Yes.
Well, he was doubled up, you see, with a pain as well as jumping about.
Well, how does a chair leg come into this?
Well, he said as the formalities might take some little time and he was in pain, he might like to be put under sedation till they were completed. He said it was one of the few concessions that the law allowed to human frailty, and we might as well take advantage of it.
By striking him over the head with the chair leg.
Is this common practice?
I've had no personal experience of it, my lord.
We were hoping to have it under the swear now, pay later scheme.
Well, couldn't all this have been done over the telephone?
Husbands ringing in from public call boxes purporting to be swearing on behalf of wives and sweethearts. Greengrocers impersonating members of Parliament in order to let rip under the cloak of privilege. Make a mockery of the whole business, my lad.
They said it could be the thin end of a very ugly wedge.
Yes, I see the force of that, I suppose. Very well.
So I said, couldn't he have voice training first?
Voice training?
I wanted his voice to be in tip-top condition, so that he'd do full justice to the oath when the time came. Otherwise, it was money down the drain.
Surely no man in his right senses would attempt to nail up a picture of the infant Jesus unless his larynx was in reasonably good nick, as the expression is, to start with. Oh, I think we've had enough of this witness and can now revert to the original witness whose evidence was interrupted.
As your lordship pleases.
This woman has had an unusually long run for her money, and as she leaves the court, clearly seems to realise it.
Oh, yes, very satisfied. I've no complaints at all.
A very generous allowance of time.
Yes, I was very pleased.
The chief planning consultant is now back in the witness box, and the examination can continue.
Not all, by any means, of the various projects on which cosmic planning consultants have been called in as advisors have received universal acclaim. I'm referring in particular to the scheme elaborately worked out by you for a midnight sunbathing Lido on the Dead Sea, over which you were severely criticized in having failed to take into account the relative absence of effective sunlight at that time during the 24 hours.
I won't deny we had to take a certain amount of stick over that.
You were, if I may refresh your memory, very frank and open about it at the time, going so far as to admit in a letter I have before me now, which I shall pass to his lordship and to the jury presently, that in some respects you had failed, in your own words, to do our homework on this one.
We tried to take a reasonable line on it, certainly.
There are a number of letters relating to all manner of enterprises, including this one, addressed this time to a Mr. Driscoll. Dear Mr. Driscoll, it begins, it would appear to have happened again. We seem plagued by gremlins, and it seems that your decision to build a bird sanctuary underground was made on advice wrongly given to you by us. This is the kind of slip-up which can, however, all too easily occur, as I am sure you realize, and should not be blown up out of all proportion. Neither would it be advisable to shout it too much from the housetops, as this could make difficulties for everyone. Sealed lips, in other words, seem once more to be the order of the day.
Lay people who don't have the experience to judge can sometimes put the wrong interpretation on things, such as when, for example, a building falls down or a bridge collapses.
As when a tower block some years ago collapsed like a house of cards within 10 months of being completed. A tower block on which cosmic planning consultants were the advisors.
That was due to a fault in the design, for which we refused to accept any responsibility.
It was precisely the design you were brought in as advisors, was it not?
Our function was to tender advice, this we did.
Advice on the basis of which the block was constructed in such a way as to fall down shortly after being put up.
The advice we gave was given in good faith. There was no obligation whatsoever on the part of the construction company to follow that advice. They took this responsibility entirely on their own initiative. We're perfectly in the clear in the matter.
As in no fewer than 231 disasters of a greater or lesser magnitude on which, over a period of years, you were acting as consultants.
It's too easy for outsiders to apportion blame in these circumstances. Our conscience is perfectly clear.
It is clear that counsel is not going to be able to shake this witness in any way or wring any concession out of him that might damage his position, notwithstanding the damage that might have been done to others, though the case is by no means over yet. Join us tomorrow for another installment in the case of Cosmic Planning Consultants versus the Rosenberg Research Foundation. The case from which you're about to see further edited highlights is a very fictitious one, and the proceedings are not as legally accurate as they might have been in the hands of a more competent writer. The characters in it are played by actors, and the jury is made up of people who've expressed their willingness to arrive impartially at any verdict required of them. It is a complex and unusual case now in its fourth day concerning the sighting of lavatories for an old people's home some 3,000 feet below the building which they were designed to serve, thus subjecting the old-age pensioners to considerable trouble and inconvenience. It is the task of counsel for the plaintiffs, who are alleging libel against them on the part of their clients in respect of this, to minimize the gravity of the error, and thereby show that the charge of gross incompetence is unfounded. The credibility of an expert witness depends upon the effectiveness with which counsel is able to establish his credentials at the very outset by skillful and subtle questioning.
You are your Professor Upshot, and you occupy the chair of comparative geriatry at the University of Wakefield.
Oh, yeah, that is true, yes.
You're the author, are you not, of a number of books, some of which are addressed to a wider public. Ill-lit by moonlight,
yes.
My encounter with the largest hippopotamus in the world, being perhaps the best known of these.
Oh, yes, that is the one that my popular reputation is based upon, I think, yes.
You're also the author of the standard work on high-altitude geriatry, yes. Which has gone into a number of editions and been translated into numerous foreign languages, and which has become something of a textbook for students on the subject, called Mountaineering at 90, Dream or Reality.
Yes, it runs the other one a close second.
You're not uninstructed, therefore, in these matters, and might indeed be said to be a worldwide authority on the effect of altitude upon the elderly.
Yes, I would go as far as to say that, yes.
Would it be true to say that the governments of Nepal and Afghanistan were interested in the experiment being carried out at this spot in the Cairngorms, and that they were, in particular, interested in the light it might shed on the problems of establishing old folks' homes in the Himalayas and elsewhere?
Oh, there were deputations from all parts of the world. The Andes was another area where high-altitude geriatry was of prime concern.
The high spots of the world.
Oh, yes.
The necessity in those regions of acclimatizing the elderly to the making of journeys up and down sheer and relatively sheer rock faces might well be exercising the governments of these countries, might it not?
Oh, yes, it was the #1 topic.
So that, in order for the pilot scheme being tried out here in the Cairngorms to be of use in the widest possible way, it would make absolute sense, by placing the lavatories at the bottom, to ensure that data might be forthcoming as to the feasibility of such journeys up and down.
Oh, absolute sense. It was the crux of the whole exercise.
An imaginative way, in fact, of achieving a sound and useful objective.
It was the one thing that commended the scheme to those of us who were invited to look at it at an early stage.
And to what extent is 3,000 feet an acceptable height when elderly people are called upon to make the journey both up and down several times a day as well as during the night?
Oh, by no means unacceptable, given a certain degree of fitness, of course.
Fitness by no means beyond the reach of, for example, his lordship, or of such of the old-age pensioners who are in court at the moment.
Oh, yes, indeed, yes.
It has been said that you are as young as you feel, and that the secret of eternal youth is available to any one of us who chooses to open his mind to it.
Queen Victoria is an example here, I think.
It has been plausibly suggested, has it not, that even as quite an old woman, Queen Victoria, who harboured a secret longing to wheel a wheelbarrow through streets broad and narrow, crying cockles and mussels, alive, alive, oh, and, in fact, to do so, moreover, at dead of night, did, in fact, on numerous occasions, succumb to this craving.
It's not too fanciful to imagine the scene where the sleeping populace of Windsor were awakened from their beds to cheer her as she did so.
Cheer her, indeed, until they were hoarse before, after a quick gargle, returning to bed and sleep once again.
Oh, indeed.
It might well be, might it not? It might be this kind of activity that was the secret of her eternal youthfulness.
I simply cannot go along with this blatant leading of the witness. It's a waste of public money to bring him here at great expense if all he has to do when he gets to court is to find various ways of answering yes.
I stand corrected, my lord.
Are we cross-examining?
With your lordship's permission.
By all means.
Would it be true to say that it makes nonsense of the whole notion of high-altitude geriatry if old-age pensioners on their journey back to bed in the small hours miss their footing and finish up in heaps at the bottom?
It may well be taken into account as a possibility when constructing a home of this kind. Indeed.
I put it to you, it was not only not so taken in this instance, but that it was blatantly, either by negligence or design, ignored as a possibility.
Oh, by no means. It may well be taken into account as a possibility and then ignored.
A calculated risk.
A risk worth taking in view of the purpose behind the whole exercise, which was in part to discover the effects of such minor oversights in developing buildings of a similar nature.
Thank you.
I have no further witnesses, my lord.
That is your case.
It is, my lord.
It is now for the defence to open its case. Now, whilst we're waiting for this to happen, this might be the moment to go outside the courtroom where witnesses are waiting to be called for other cases which are going on in the same building concurrently with our own and are passing the time in small talk.
The bottom seems to have fallen right out of horse brasses.
Right out. Never seen anything like it.
I should be out looking for the wife. Left this message on the table for me. I'm being held prisoner in the Lake Isle of Innisfree by W.B. Yeats.
He can be had up.
It's a death trap, that place.
They can usually look after themselves, women.
I remember the Queen went missing once.
Counsel for the defence has now opened his case and is questioning his first witness, an experienced mountaineer.
Am I right in saying that you are an experienced mountaineer?
Yes,
Of several years' standing.
indeed.
Perhaps you would take a look at the model here in the well of the court and show us by means of the model the relative positions 3,000 feet apart of the old people's home and the lavatories serving it.
To what extent can this be described as the same model as heretofore?
It has sustained damage, my lord, and certain corrections may have to be made in respect of the scale.
What is the extent of the damage?
It was sat upon whilst in safekeeping, my lord.
Sat upon?
Yes, my lord.
I see.
There's also some marmalade, my lad, in one or two of the interstices, which has arrived there somewhat mysteriously, and points to there having been a moment, possibly more than one, when the model was the subject for discussion over the breakfast table. Or perhaps it was being used for some other reason, such as to prop up a copy of a daily newspaper.
Where is this marmalade?
Not in any vital spot, my lord.
Does the marmalade invalidate the model in any way?
Not significantly, no, my lord. There are also some crumbs of toast. But these are a non-strategic area, so far as the case is concerned, and it is my submission it need not trouble us if the defence agrees.
I'm perfectly happy.
Yeah.
Oh, well, as long as the model was in safekeeping at the time, which I understand it was, none of this furnishes any sound reason. Once the necessary corrections have been made, why it should not continue to be used.
I'm obliged to your lordship.
Perhaps you could indicate the route which would have to be taken by an old-age pensioner taken short in the night.
Well, of course, the mountain itself, which they would have to negotiate, has now been sat upon. But allowing for that, it would be up here. Along, around this bit, then they would have to negotiate round the overhang.
Which is not easy in bedroom slippers.
Virtually impossible.
May he be shown Exhibit 2. Perhaps you would give us your expert opinion on the effectiveness of bedroom slippers when these have been modified in some such way as we see done in this instance and fitted with crampons.
Under ice or snow, these would be virtually useless. Precipitate an avalanche and cover anyone who was on the throne under a few 100,000 tons of snow.
Not a happy eventuality, perhaps, for the unfortunate person so visited.
Never sit on the throne again with a quiet mind.
It might be said, in fact, that these bedroom slippers are all right for anyone negotiating a rock garden in full daylight. But worse than useless for the sort of terrain we are concerned with here.
I wouldn't wear them. Put it that way.
So, that in other words, the route is, in your view, an impossible one, even when there is no such distortion as on the model here.
Out of the question.
Thank you.
A formidable line of argument, which has clearly impressed the jury, and which it will now be for the plaintiffs to attempt to demolish in cross-examination.
You say you found this route an impossible one.
Virtually impossible.
Would it be true to say that a mountain goat could negotiate it without any difficulty at all?
I'm not familiar with the habits of mountain goats.
It would be a reasonable supposition, though, would it not, from what you know of mountain goats?
I dare say a mountain goat would make a reasonable stab at it, yes.
In other words, a mountain goat could do so, and yet an old-age pensioner, made in the image of God as he is unable to do what a mere goat, not so fortunate to have been made in God's image, can do with one hoof tied behind his back, so to speak.
A mountain goat can do precious little else but leap about on mountains. That's what it's there for.
And what you're saying, then, amounts to, correct me if I'm wrong, that though the structure known as Bellamy's Folly may be perfectly acceptable as a home for goats who are past their prime, it is to be denied to God's children in their declining years because they're in some way inferior in not being able to reach lavatories which have been placed at the bottom with quite the dexterity with which a goat might do so.
It's not a question of being inferior.
You drew our attention to the overhang. How, in fact, would a qualified mountaineer negotiate such an overhang?
Well, one would first find a toehold. Then give a sort of a heave. And Bob's more or less your uncle.
When you say more or less your uncle, is he your uncle or isn't he?
It depends, my lord, on the nature of the overhang and the strength of the heave.
Would it not be true to say that Bob is, in fact, your uncle?
Depends which Bob you're referring to.
Well, which Bob are you referring to?
I was referring to a hypothetical Bob.
A hypothetical Bob, who I suggest is as much your uncle is, if not more so.
With respect, my lad, I would suggest we are being led here on something of a wild goose chase.
Yes. Where is this line of questioning leading?
I shall be in a better position to say, my lord, when we've got there.
Well, I think we're chasing a blind goose up a wild alley and might well adjourn at this point. We will resume at 2 o'clock.
It seems that counsel may have cooked his client's goose at this juncture. If so, he has now no alternative but to lie on it. We shall see. As we come back at a somewhat later stage in the hearing, counsel has just finished his examination of his second witness, an old-age pensioner who has sustained injury by falling several hundred feet and missing the mattresses placed at the bottom. Counsel for the plaintiff is about to cross-examine.
We've heard your story as to how you came by the injuries you sustained, which is that you missed your footing and fell in consequence some several hundred feet down the mountainside.
That's right.
I would like to suggest to you that your injuries were, in fact, sustained in a quite different manner.
No. I fell from this ledge and missed the mattress at the bottom.
Let me take you back a number of years to the time when you were quite a young man, 20 years old, in fact. At that time, like a number of other young men who were affected by the same craze, you were bitten by the bug, if I could put it, of ventriloquism.
I dabbled.
Ah, you dabbled. But with scant success, I fancy.
Well, I never got to the top.
I would put it to you, never even rose from the bottom.
Well, it wasn't for the want of trying.
It is by no means clear what line of argument is being pursued here, and the judge is himself obviously far from certain.
In recent years, the memory of that failure has come increasingly to irk you, has it not? To the extent that you've begun, in a somewhat clandestine manner, to take it up again, retiring behind closed doors in order to try, not altogether successfully, once more to throw your voice from one end of the room to the other.
The doors were not closed.
Neither were the windows, I venture to suggest.
What have the windows got to do with it?
My contention is that they were open, my lord, and that witness, whose voice is a very powerful one, might well, in endeavouring to throw his voice, have found his voice instead throwing him.
Was this an upstairs room?
It was sort of upstairs.
And you went out through the open window whilst your voice, which was more powerful than you thought it was, remained where it was in the room across which you were trying to throw it.
I landed in the flower bed.
I see.
These injuries, in short, were sustained in a manner totally at variance with the ones that you have described to us.
Some of them might have been.
And the story, therefore, of your fall, having fallen from a ledge several hundred feet up in the Cairngorms, is the purest fabrication from beginning to end.
Well, I suppose it could be.
Thank you.
Consternation. It is by no means usual for a witness to admit to quite such blatant perjury in the witness box and while under oath, and it is something which will clearly have to be dealt with elsewhere and at some other time. Meanwhile, as the effect of this extraordinary admission dies down, the hearing continues. There is a slight interruption at this point as a witness attempts to force his way into the witness box. He is clearly in a state of some distress, and the hearing must go into abeyance for a few moments for his needs to be attended to as a matter of urgency. Judge and counsel are in conference over the most suitable way to deal with the emergency, as witness, bursting with evidence which he obviously cannot keep bottled up for very much longer, strives as best he can to contain himself.
You represent Lactic Dairies?
That is so.
And should have been here yesterday?
Yes.
To give evidence in a totally different case?
I was led to understand I could give evidence on this case instead.
Why were you not in court yesterday when you were required?
Having trouble with one of our roundsmen, my lord.
In what way?
He was playing ducks and drakes, not to put too fine a point on it, my lord, with his milk float.
Is this really serious enough to prevent your coming here to give evidence?
The float, my lord, is by way of being the tradesman's badge of office. It's held by him on trust for the duration of his tour of duty. He is the temporary custodian.
When you say he was playing ducks and drakes with it, what does this mean in plain terms?
Not to beat about the bush, my lord. Mince words in any way. He'd gone down to Brighton on it.
Well, is it not in the nature of this milk float that it is open to abuse in this way?
We do our best to prevent it, my lord.
What evidence is it that this witness is proposing to give?
It is in respect of a case of assault and battery, my lord, involving a husband and wife.
It's highly irregular that a witness called to give evidence in one case should come to court expecting to be accommodated on a different day in another. If evidence cannot, for whatever reason, be given at the proper time and in the proper place, it must be bottled up until such time as there is a similar case of the same kind.
The witness is clearly in a state of some distress, my lord.
How long will it take you to get whatever it is out of your system?
A couple of minutes, my lord, depending upon the questions.
Very well. And in future, you will make sure that you're here when you're required. Give your evidence to counsel, and I shall instruct the jury to ignore it accordingly.
Thank you, my lord. I'm much obliged to you. It's a great relief.
Where were you on the night of the 24th of August last year?
I was on holiday in Scotland.
And could not therefore have been able to witness a case of assault and battery in Wanstead?
No.
Thank you.
No questions, my lord.
You can stand down.
A second old-age pensioner, Mrs. Olga Freetumble, has been called by counsel and is now likewise being cross-examined by plaintiff's counsel, who is deploying a neat and intriguing line of argument.
Old-age pensioners, we are given to understand, making the journey, sometimes in the middle of the night, and missing their footing, show a tendency to arrive at the bottom with undue suddenness.
Oh, they do. I did myself.
Which is disconcerting and could indeed be fatal.
It really was.
We've all heard the story, have we not, of the clumsy housemaid who, dropping a plate or a cup to the floor, where it smashes beyond repair, is heard to exclaim indignantly, "But I only let go of it for a split second." Whereupon she receives the retort, "It's enough, Mavis."
Yes?
Now, it well may be, may it not, but for the force of gravity, that plate or cup could have remained intact to this day.
No reason why not.
It is now some 300 years or so, is it not, since gravity was discovered by Sir Isaac Newton.
Well, I suppose that would be so.
Indeed, he had been hunting high and low for it, had he not over a considerable period of time.
I wouldn't know about that.
And the search was finally crowned with success, if legend is to be believed, when he came upon it, so we are told, in the back of a boot and shoe cupboard, to which he'd gone in search for something else, and saw it crouching down behind, so they say, a roll of linoleum, swathed from head to foot in some kind of curtain material, doubtless hoping thereby to be mistaken for Henry Irving in A Midsummer Night's Dream. A vain hope, as it turned out, for Sir Isaac recognised it at once and made the famous remark, "You are the force of gravity, and I claim my £5. Now, had he not had the presence so to do, it is possible that gravity may have eluded him, and that, in consequence, we might still be looking for it.
I suppose that could be true, yes.
Where is this line of questioning leading?
I was endeavouring to demonstrate, my lord, that the force of gravity is a significant factor here. and that the lion's share for the blame for the witness's injury must be laid fairly and squarely at the door of Sir Isaac Newton, since it was his discovery of gravity in the 17th century that may be said to have set in motion the course of events which have culminated in these injuries. And that if this be so, my clients are blameless in the matter.
Is it your contention that if the force of gravity were done away with, no harm would have befallen these unfortunate people?
It is my submission, my lord, that they would have been able to take their time getting both down and up.
This is a line of argument so potentially damaging to the defence that counsel must lose no time in scotching it.
Many is the time, I dare say, when all of us, in a moment of exasperation, as a precious vase or ornament has fallen to the floor and smashed beyond repair, have said to ourselves, "To hell with gravity and all its works." You must indeed have uttered some such expostulation yourself, I imagine.
Oh, yes, many a time.
But gravity is holding the universe together, is it not?
Well, so they say.
So that were your wish, and those of countless others in like circumstances, to be granted, and gravity be indeed done away with, the universe would forthwith fall apart at the seams, and you and I would wake up one fine morning, only to find ourselves stepping out of bed into empty space.
Oh, I suppose that could be so, yes.
There are those who might in such a situation be disposed to say, what's happened to the flaming universe all of a sudden? It seems to have disappeared off the face of the earth. Adding, perhaps as an afterthought, it must have gone round to its Auntie Flo's for some reason, doubtless having heard of a death in the family and wishing to offer its condolences. And its being early closing day at the butcher's would lend some plausibility to such an assumption, since there could be little other reason for its absence.
Well, I wouldn't know about that.
At all events, no matter with what fervour one might on occasion wish gravity to the devil, the disappearance of the universe would be something that, as an old-age pensioner, you would not greatly appreciate being saddled with, having enough to contend with already in these inflationary times.
Oh, no. I wouldn't like to do without the universe.
You'd
no.
kick up a bit of a stink, in fact, to use a homely expression.
I think it would be a liberty.
You think it would be a liberty?
Yes, I do.
Thank you.
On that somewhat unsettling note, we must leave Crown Court for today. Join us tomorrow for another instalment in the case of Cosmic Planning Consultants versus the Rosenberg Research Foundation. The case from which you're about to see some further edited highlights is just as fictitious as before, and the procedure no more legally accurate. The characters are still being played by actors, and the jury is made up of people who at the end of the hearing will retire to the jury room in order to be told what verdict to come to. We're now entering the 73rd day in the case of Cosmic Planning Consultants versus the Rosenberg Research Foundation, in which by an oversight, an old people's home 3,000 feet up in the Cairngorms has been provided with lavatories situated at the foot of a sheer precipice several thousand feet below. It's been an exceptionally protracted hearing, during which both sides have put up what the judge has referred to as a veritable smokescreen of red herrings. It's in the nature of red herrings, however, that sooner or later they come home to roost, and in these final stages of the hearing we may expect to hear the flapping of their wings. Defence counsel is questioning a vital witness.
Why is he dressed in this peculiar manner?
He is a Sherpa, my lad, Himalayan mountain guide, whose occupation it is to lead climbers to the summits of such mountains as Everest.
Everest?
Oh, yes, my lad.
What is there about the summit of Everest that makes it so vital to arrive there?
It is done in order to keep such people as Sherpa Solo Kombu here in business, my lad, and so prevent their becoming a burden on the state by reason of unemployment.
I see. And you have come here straight from the Himalayas?
Yes, sir.
Having had no time to change?
I was in the middle, sir, of taking a party up the foot of Everest when I was summoned to be here to give evidence to the court.
Where is this party now?
They're on the mountainside playing Ludo, my lad, awaiting his return.
Are they safe?
Oh, yes, sir. They're all roped together. I said I wouldn't be long.
He came here hot foot, my lad.
Hot foot?
Yes, my lad.
How hot?
Not very now, sir.
He arrived some moments ago, my lad, and has been cooling his heels.
Do you want time to cool the rest of your feet?
No, thank you, sir. I'm fine.
In view of the people waiting on the mountain for his return, my lad, it might be better to expedite matters in respect of this witness.
As long as his feet are hot, though they may be, still in certain parts, not doing any damage to the floor of the witness box.
There are scorch marks from a previous witness in another case, my lord, but no further damage.
Very well.
Counsel can now begin questioning the witness as to his dealings with cosmic planning consultants.
Ineptitude is a word which has been bandied about with some frequency in respect of operations advised upon by cosmic planning consultants, and in far-flung places.
Oh, certainly so in the Himalayas.
Now, when you were called upon to act as guide to such of these old folk as needed to make the descent in the small hours, were you surprised in any way to learn that it was necessary for them to negotiate so difficult a route in order to be able to attend to a simple call of nature?
Not when I knew who the planning consultants had been.
Would it be true to say that they were a byword for incompetence wherever you went?
Absolutely.
They were indeed, not to put too fine a point on it, a standing joke in places as far apart as Worthing and Walla Walla, than which no two places could be farther apart.
Oh, difficult.
Unless one perhaps were to take a very circuitous route.
Exactly.
Now, during the course of your duties, in and around Bellamy's Folly, here at the summit of this escarpment in the Cairngorms, you must frequently have heard remarks passed by the pensioners in which the sighting of the lavatories was the subject.
It was the sole topic of conversation?
Nor was the tenor of these remarks notably flattering to cosmic planning consultants, under whose aegis they had been placed there so awkwardly.
They thought it was a disgrace.
In a sense, therefore, it would be true to say that this particular boob, if that is not too strong a word, was, in a manner of speaking, a vindication of an already widespread and long-standing reputation for errors of a startling magnitude.
That would be so.
Thank you.
This is a strong witness whose evidence is potentially very damaging to the plaintiffs, whose counsel must now seek to undermine his credibility in the eyes of the jury.
As an experienced mountain guide, who has been on many an expedition to Everest, among other mountains, you were called in on this scheme at an early stage to reconnoitre in the Alps for a suitable site prior to Bellamy's Folly being, as it were, found to be tailor-made for the purpose.
That is so.
And you were combing the Alps on this errand and were at the top of the Matterhorn when news reached you that the site had been found near a home in the Cairngorms.
Yes.
What was your reaction to the news, as best you recall?
I was a bit put out.
You were, I suggest, hardly chuffed.
No.
You used the word typical, in fact.
I may have said something of the kind.
I suggest your disenchantment with this eventuality coloured your attitude and your thinking not a little.
Not really.
There was a further cause for dudgeon as well, was there not, when you returned for a time to your more familiar haunts in the Himalayas, where you were wont to stray when not on duty, in the search, perhaps, for the perfect Himalaya, the Himalaya of your dreams, the Himalaya which nevertheless perpetually eluded you.
I can't remember any dudgeon.
Well, let me remind you. It is a fact, is it not, that while you were traipsing round the Alps on behalf of the defendant, you picked up the habit of yodeling from such Swiss Alpine guides as you were thrown amongst from time to time, insofar that it began to grow on you and you found yourself doing it almost by force of habit, unaware that you were doing so.
I indulge in the odd yodel.
Rather more, I would suggest, than the odd yodel. So much so that there were complaints. And you had more than one brush with the Nepalese government about it.
We communicated.
What was the substance of those communications?
I can't remember.
Let me refresh your memory once again. The burden of the complaints made to you was that your yodeling, by your yodeling, you were keeping the entire sub-Indian continent awake at night, since you by now had taken to nocturnal yodeling, and that it was a case, not to put too fine a point on it, a belt up or else.
It was trumped up. I yodeled in an undertone at night.
Can you give his lordship and the jury an example of what you mean by yodeling in an undertone? Perhaps not a welcome sound to the ears of the sleeping populace around.
It echoed.
Precisely. From Himalaya to Himalaya, and thence south to Cawnpore, and even more remote regions. If the wind were in the right direction, you could have been heard as far away as Tibet.
Only once.
I would suggest to you that reactions to your yodeling were characterized by a singular lack of restraint, and that arising out of this, hackles rose on both sides.
Not all that much.
And it is this feeling of suppressed rancour that colours your interpretation of the remarks you say you overheard from the old age pensioners when descending to the lavatories at night and at other times.
I'm only saying what I heard.
Some cheerfully disrespectful remarks. Remarks indicative of a certain degree, perhaps, of blunt humour, from which there was a total absence of any kind of rancour, and partaking of the nature of light-hearted pleasantries, not to be taken too seriously.
The air was blue.
At such an altitude, in so rarefied an atmosphere, conversation might well have begun to flag, but for some such fodder to keep it going, might it not? And the pensioners might well have been grateful for some topic of this nature, to keep boredom at bay.
That was not my impression.
Nevertheless, it's possible.
It's possible, yes.
Thank you.
That is my case, my lord.
The hearing is now entering its final stages as counsel for plaintiffs embarks on his speech to the jury.
This case, members of the jury, has been marked by a number of irrelevant side issues which I propose to deal with and dispose of at the outset. We've heard evidence, for example, from expert witnesses in respect of rubber teeth. Rubber teeth, it has been said, have the advantage that if they happen to fall out, they bounce. Now, it is not perhaps generally known, for instance, that a tiger in the wild can be driven clean out of its mind by the simple stratagem of replacing its own teeth under a suitable anaesthetic with rubber ones. When next it attempts ineffectually to tear at its prey, the hapless tiger, unaware that rubber teeth have been substituted for its own, will look around in total bafflement as it tries ineffectually again and again to dismember its prey. What of the prey thus spared? Will it not perhaps start as a result to adopt a perhaps fatally la-di-da attitude under the erroneous impression that it bears a charmed life?
It is clearly part of counsel's strategy here, as it has been throughout, to deflect attention away from those matters which are germane to the case and concentrate instead on side issues of doubtful relevance. And this is what is happening here.
The jungle is a cruel place. And we would be wrong to suppose that this in any way justifies the contention on behalf of the defendants of this action, the Rosenberg Research Foundation, that their remarks were in any sense fair comment.
Rubber teeth having been effectively disposed of, counsel winds up his speech to the jury by referring to a point he himself raised earlier in the hearing and wishes now to heap scorn upon.
Much has been made during this hearing of the responsibility devolving upon Sir Isaac Newton in having discovered the force of gravity in, we are told, the back of a boot and shoe cupboard. Now, had he not done so, we are invited to assume, no harm would have befallen any of the unfortunate old age pensioners whose precipitate arrival at the bottom of a 3,000-foot drop has so incommoded them. No, this is not a matter that I propose to spend time on now. Sir Isaac Newton's was a mind, in the poet Wordsworth's celebrated phrase, forever voyaging through strange seas of thought alone. Now, it is there, I would suggest, that it might be left.
There, I think we might also leave it. We will resume at 2:15.
As we return to the court, counsel for the defence is making his final submission to the jury, and we pick him up as he enters upon his peroration.
It has been said, members of the jury, that to err is human. I would suggest to you that to err no fewer than 231 times, and on a quite disproportionate scale, as cosmic planning consultants have done over the years, is not human, but superhuman. The plaintiffs are bringing this case because they say they have been injured in their reputation by the words complained of. One might well ask, what reputation? A reputation for making monumental boobs? Cock-ups on a scale altogether unprecedented in the field of engineering? I would suggest to you that their reputation, so far from being in any way injured, has been abundantly vindicated. We have heard how venture after venture on which the plaintiffs have been advisers has come to a disastrous end. We have heard, indeed, of no single project which has succeeded. The record is one of disaster following upon disaster. They have, it might be said, a reputation for ineptitude unmatched anywhere in their field. All my clients have done in publishing the words complained of is to advance that reputation, not diminish it. In my submission, therefore, the plaintiff has failed to establish his case, and I would ask for judgment for the defendants with costs.
It is clear that this line of reasoning has impressed the jury and is causing some concern to the plaintiffs, who must now be anxiously awaiting the judge's summing up.
Libel is the publication of a false and derogatory statement about someone which may have a tendency to injure him in his office, profession, or trade. The defense is one of justification and fair comment. Now, in order that this defense may stand, you, the jury, must be satisfied that the words in question are based on facts truly stated, or that they are honestly believed to be true, and that the defendants were not inspired by malice towards the plaintiffs, and finally, that they are on a matter of public interest. What? Where?
Outside the court, my lord.
Well, is there someone there to deal with it?
It can be arranged.
Very well, very well.
Thank you.
Why does it always happen when I'm on? Oh, where's the... Oh. You are a lecturer in anthropology at the University of Wakefield.
Yes, I am.
It says here you've had wide experience in this field.
I've had wide experience in a number of fields.
How wide were these experiences?
They varied in width.
How wide was the widest of them?
Well,
was it rather wide? Very wide? Wider at one end than the other?
it bulged out in the middle.
You are not a stranger, perhaps, to experiences which bulge out in the middle.
This is a witness who, having arrived too late to give evidence to counsel from the witness box as she had hoped, must make do with a cleaning lady, in whose capable hands she can safely be left, as we go back into court, where the judge is now dealing with the evidence given by Mrs. Startferret concerning her husband's visit to a commissioner for oaths.
This is a matter which, because it has no bearing whatsoever on the case before you, you must expunge totally from your minds. For this reason, I must take you through Mrs. Startferret's evidence in some detail, since no smallest scintilla of doubt or uncertainty must exist in your minds as to what it is you are disregarding. Mrs. Startferret's husband, you will recall, was nailing up a picture of the infant Jesus in their living room when he struck his thumb with a hammer, the very hammer with which he was proposing to knock in the nail to hold the picture. His natural impulse was to cry out, using one of a vast number of putative expletives, of which it may be sodden blast would be a fairly representative example. Mr. Startferret, being a responsible citizen, restrained himself at that juncture, holding back the oath with the help of a gag quickly improvised by his spouse the moment he saw how matters lay, and made off, accompanied by Mrs. Startferret, hotfoot to his nearest commissioner for oaths, in order to let him, as the expression is, have a right mouthful, and so get it well and truly out of his system. It was no part of his plan, however, on setting out for the solicitors in the High Street, that he should be hit on the head with a chair leg almost immediately on entering. Nevertheless, this is what happened. For what followed, I must call on counsel to refresh my memory, and the jury will therefore absent themselves for a few moments until asked to return.
It is a most unusual departure from normal judicial practice for a judge to interrupt his summing up in this way. One can only assume that a page of his notes has been made illegible in some way, perhaps by cocoa having been upset over them.
Nothing legible in my notes here as to how it was proposed to bring the husband round again after he'd been laid low by means of the chair leg.
But I think it was intended to give him what was described by witness as a kick up the backside, my lad.
Well, that would certainly be in keeping, but the whole thing seems to me to smack of the Middle Ages.
It is a bone of contention as to how best to deal with this situation, my lad. It has been known indeed for a solicitor to require help and to find himself tossing a semi-comatose client around like a rag doll in a somewhat desperate and indeed vain attempt to produce results.
Yes, a client over whom it would be a perfectly simple matter, I would have thought, to throw a bucket of water and achieve the same result much more simply.
There is a school of thought which does favour this, my lord, but it has all too frequently been known for a client to come round and kick one rather forcibly on the shins.
Yes, with the added problem that the solicitor, when so kicked, may involuntarily come out with an unpremeditated oath.
And in so doing bring the law into disrepute.
Yeah.
Instances have occurred of solicitors ending up in Dartmoor breaking stones as a result of unauthorised irregularities in the oaths procedure. And this is not an eventuality that one would wish to encourage.
Indeed not.
For many, there would be a tendency, my lord, on seeing this happen to others, to say, this is not what I came into soliciting for.
Yes, one can readily imagine some such response. It is nevertheless a matter that should be looked into with the least possible delay, possibly by the setting up of a royal commission or some other machinery such as our legislators in their wisdom may devise. I think we can have the jury back now, if you please.
Meanwhile, witness is still being questioned in the corridor outside the courtroom.
Perhaps you would care to look closely at this photograph. It is a photograph of a field, is it not, taken from the air?
Yes, I recognise it.
It is the very field, is it not, in which you had the experience. One of many, which, as you put it, bulged out in the middle.
I remember it, because normally I tend to go for the kind of experience which is the same width all the way down.
And up?
Up too.
What was it about this particular field that caused the experience you had in it to differ so radically from those you'd had elsewhere?
There were thistles.
As we go back once more to the court, the judge has come to the very crux of the matter the jury will shortly have to consider.
What you have to decide, members of the jury, is whether the words used are capable of having a damaging interpretation in the minds of reasonable people reading them or listening to them. Now, let me repeat these words to you. They have made a right old bollocks up from start to finish, and we're going to take them to the cleaners over this and call their bluff once and for all. Now, you or I, reading these words in a weekly publication or a daily newspaper, or coming across them in a letter over the breakfast table, might well be disposed to think first sight that criticism of some kind is being levelled at the person or persons towards whom they are being directed. A right old bollocks up from start to finish. But let us look at this in the context of the other remarks of which it forms part. We are going to take them to the cleaners. We are going to call their bluff once and for all. Well, these are the kind of phrases that one would use, are they not, were one in a certain particular kind of mood. If perhaps one's wife had been more than usually cantankerous at breakfast, or the car battery was flat when one was attempting to start the car in pursuit of some perhaps rather attractive young woman disappearing rapidly into the distance, one would be looking, would one not, for some way of relieving one's feelings. Nevertheless, what you have to decide, having respect both to the facts and to what you know of human nature, is whether any reasonable person reading those words, they have made a right old bollocks up from start to finish, and reading them in the context of the other remarks, would modify them in his own mind in the light of what, reading between the lines, he can infer about the writer's state of mind at the time of writing them. If he says to himself, this person, this geezer, has clearly got out of bed the wrong side on the morning he wrote this, and is just getting it out of his system at the expense of the plaintiffs, so it hasn't got to be taken too seriously, then you may feel that the charge of malice falls down, since no reasonable person would attribute malice to it. If you accept this, it would seem to follow that any damaging imputation contained in the words "they have made a right old bollocks up from start to finish" is non-existent, since no reasonable person, knowing the state of mind in which the words were set down, would believe them to be literally true. The fact, therefore, that they are literally true, if, as the defendants have tried to show it is a fact, is, you may think, neither here nor there, and may be ignored, except by those who have suffered as a result. The facts, therefore, that you have to consider are simple ones.
It is now for the jury to retire, elect a foreman, and reach their predetermined verdict.
Members of the jury, will your foreman please stand? Please answer these questions, yes or no. Have you decided upon the answers to the agreed questions which you have before you?
Yes.
Were the words complained of in the defendant's letter and subsequent interview likely to bring the plaintiff into hatred, ridicule, or contempt?
Yes.
Were the statements true or believed without malice to be true by the defendants?
Yes.
What sum of damages do you award to the plaintiff's cosmic planning consultants?
1p.
You can join us again when our cameras return to bring you another case in the Crown Court.